Legasis Partners with the topic Legal Interventions for Balancing Altered Business Relations in Times of COVID. Uh, we have an eminent speaker with us today, Mr. Suhas, Suhas Tulja, Tuljapurkar. I'm happy to welcome you, Mr. Suhas. He's the managing partner of Legasis and founder director. He's a practicing lawyer with over 37 years of experience, including as a corporate lawyer in various companies. He's one of the leading lawyers in the field of corporate governance, compliance, and ethics and legal strategies. Suhas is also a certified independent director, a certified compliance and ethics professional, and an accredited mediator and conciliator. On the social front, Suhas has developed a portal for free legal aid and advice ecosystem that caters to Maharashtra police and the martyrs' families and police veterans. Uh, as you all know the rules, it is not essential to have your video on, but please kindly have your audios off. Video is your choice, and question answers can be typed in. We can take it up at the end of the session. Over to you, Mrs. Was.
Oh, thank you. Thank you very much, sir. I think I'm not going to waste too much of time, but I will just kind of thank Gary for coming in last minute, and I will introduce you a little later to the entire audience. Uh, what we are trying to do is actually look at what are the legal implications of COVID-19, especially when it comes to businesses which are situated in India, the Swiss businesses situated in India, Indian businesses, and what does it take. So just kind of couple of caveats before we move on to our main agenda. I think this session and the webinar is for general awareness. It's not a legal opinion or advice because each one's facts may be different. Also, the pandemic 2020 situation is so dynamic. It's uncertain, it's unpredictable. What we identified as risks today and what we have not identified may drastically vary tomorrow or within a short span of time. We are seeing a very, very dynamic world today. The third point which I want to make is actually this is a major defining moment for global, also local economics. And we are expecting new set of legislations and laws that would emerge and that would impact global as well as local businesses. And these legislations will have probably a retrospective effect. Some of the things that we are going to present during this webinar, I look at it as Eagle's View approach. We will do a deep dive on those issues, but then all the issues that are kind of today bothering us are not getting covered through this webinar. It's a limitation of the media here. Having said this very quickly, I want to express my gratitude and our gratitude from Legasis as well as Swiss Indo India Chamber of Commerce to at least one doctor, one healthcare specialist, one light artists, and one actually artist uh, who have made our days, who have actually relentlessly worked. And I want to introduce you to Dr. Ajit Mogekar. Ajit, you there? Yeah. And I think Ajit is MD. He's a pulmonologist and critical care specialist from Cleveland Clinic, Ohio, USA. Uh, the doctors and the healthcare experts have actually worked tirelessly over time, and they've saved everyone, despite of their environments being vulnerable. Uh, Ajit and Alkaji, no words from our side can express the gratitude. Uh, you're thorough professionals. While the entire world is indebted to you, we just want to say big thanks to you. Ajit, do you have any advice to us? Any learnings for during this period?
Thank you very much. I mean, it's really kind of you to have me in this forum. I mean, all I can say is, I mean, these are unprecedented times, and the social distancing and lockdowns do work. They help flatten the curve, and so that the healthcare systems don't get overwhelmed. if the healthcare systems get overwhelmed, that's when we see a lot of deaths, as happened in New York. In Cleveland, we are fortunate that we shut down things early, and so our curves have been pretty flat, and it's been good for patient outcomes. That's all from my side. I would just say, stay safe, everyone, and I'm sure we'll get over this soon. Thank you.
Thank you very much, Ajit. Thank you for joining us, and thank you for taking care of those patients and all of us so that we remain safe. Thank you very much. May I request Alka ji, Alka Patil, who is assistant matron at KEM Hospital, Mumbai. She's been working relentlessly during this period, and I think hats off to you, Alka ji, and all your friends and colleagues who have dedicated number of hours for caring those patients who come into the hospital. Thank you very much. A big thanks to you. Uh, would you want to share some thoughts?
Yes. First of all, thank you very much, Suhas, for inviting me. I am really touched by your words. We need everyone's support for fighting against COVID-19. So, my message to everyone is please stay at home, stay safe, and please follow good hygiene. Thank you very much.
Thank you very much, Algaji. We're all there to help you do your work. Do not worry about other things. Focus on your professional duties, and uh, we will follow your advice. We will stay safe. We won't overwhelm the medical facilities. Thank you very much. Uh, Gary, thanks a ton for joining us. I think what you are spreading as a light of hope, message of hope, I just want to kind of ask you, what does it take to realize a vision? How did you think of this concept? Entire India is your fan today, and I'm sure each of those countries whose flags are there up on the peak, I think, are your fan. Will you please share with us how did you conceptualize this thought? How did you implement it?
Thank you very much to invite me for this incredible web meeting here. I'm a fan of India. I was there 10 weeks ago to check out for an event at the Swiss Embassy. I fell in love with your country. And to answer your question, a vision. A vision is something which is coming into your head, in your brain. And when that vision or this idea is catching your heart, then the passion is coming in. And when you have passion for something and education to realize this and experience, then you have to realize this. And this is all about visions. Do it with passion. Believe in humanity. Can you hear me? Yeah.
Yeah, sure. Go ahead.
Okay. You believe in humanity, and then you do with all your efforts, with a great team and great people and supporters, you realize this. The success will be there for sure. So what we needed to do these LiDAR projections on the Matterhorn is, of course, a great team of photographer and filmers, my team, my light assistant, a cook. We have a famous cook in our team. And then we survived 3,000 meters altitude below the Matterhorn, and we projected during 5 weeks 1.6 kilometer, a picture of 1.6 to 1.6 kilometers in a special tailor-made huge projector giant. It's a unique one in the world. And that's how we realized this project, this vision of Zermatt, the community of Zermatt. It was the idea of them to give out a sign of hope to the world. So I was very, very touched to realize this, and also to put all the flags, even of the India flags, on your hope. Let's say, put it this way.
Gary, thank you very much. It's a brilliant thought. As I said, I think the entire nation is your fan today for having given us that hope, and you're always welcome in India. I mean, it's amazing today that when we're sitting here digitally to look at these pictures and take it as our theme of making sure that the world tomorrow would be better, and that the world will fight not only COVID and coronavirus crisis, but we will come out winner. And the hope is not only a matter of something which is up there in the air, but that gives us tremendous confidence to ride over these problems. Thank you very much, Gary, and thanks a ton for joining us today.
Thank you.
Wish you all the best from our side. Whenever you feel you need to reach out to somebody in the continent, we are here to help you.
Thank you. Have a great day and stay healthy.
Thank you very much. Thanks a lot, Gary. I'm just going to move on to Swati Nahar. Swati is an artist who kind of actually gave a colorful tribute to the healthcare specialists across the world. Swati, this is your picture, and thank you very much for drawing it for us and giving it to us. Would you want to share your thoughts on how did you conceptualize this? This is kind of today a very simple picture at one end, but at the same time, it's giving a message that everybody in this world need to collaborate together, need to be together, and look at colorful times in future. Swati, over to you.
Thank you so much for that introduction. And yeah, I mean, I just realized how effective all of us work together, and it was something we had to overcome together. And at this time, it's supposed to be like that when we're all united. And the best way that I could, portray this was through painting, because that's what I do best. And yeah, that's what I did.
Swati, would you please switch on your video? We want to see you. We want to acknowledge and recognize you.
Yeah, sure.
Oh, thank you very much, Swati. There you are. I think thanks for joining our webinar.
Thank you. Thank you so much.
Thanks for playing colorful tribute to all the doctors, nurses, and healthcare specialists. Thank you very much.
Thank you. This is a very simple thing I've done.
Yeah, thank you. Thank you very much. I'm going to move on to our main agenda, which is really what is this pandemic 2020 or COVID 2019? How the people are looking at it. Somebody like the IMF chief, uses or borrows the phrase saying that we need to now be outside our comfort zone when they talk about what needs to be done in this crisis. IMF also says this crisis is like no other in the world. The UN Secretary General says this is the greatest test since World War II. Bill Gates talks about coronavirus pandemic, saying it pits all of humanity against this virus. I think one bottom line that as a humankind and human being, we've been taught right from Mahatma Gandhi to everybody, Nelson Mandela, is to say that you may be confined, but you're not broken. And we will not only fight coronavirus, but we'll come out winner. That's the resolve with which I think the entire world today is collaborating, working together, recognizing everything that needs to be done for the pandemic. Coming to more mundane issues, such as what are the legal implications, the agenda today, and I look at it from the point that, overall there are business risks during COVID-19. The time seems to have stopped. We will look at some of the statutory and regulatory pronouncements, take an overview of that. We'll look at what are the government actions, government and administrative actions that have been taken. From a lawyer's perspective or legal perspective, we'll look at the contractual implications, what is force majeure, what is act of God, and lastly, we will look at some of the business relationships that are coming under stress and what are the kind of alternatives today and how we look at balancing these business relationships. There is a new meaning that will come to business relationships, is my perspective. Just looking at the overview, or let's say statutory and regulatory pronouncements in the overview in Indian context. And throughout this webinar and this presentation, I'm going to use some of the art forms that artists have come out with during the COVID period or during the lockdown. There is an interesting line of artists who have come up, and the graffiti again is becoming very popular. So I'm going to use that all through the presentation and try to explain. And again, I'm going to thank each of these artists, like Mr. Arjun Das, and there is graffiti artists which are unknown. I'm using this. I don't own a copyright on these art forms, uh, but I think it's very interesting to look at this during the coronavirus and lockdown situation. So there is a complexity with which today the government orders are being issued. Some of these orders are legislations or their laws or their legislative orders. Some of them are directions. Some of them are notifications notified by the government. Uh, Few of them are merely matters of statement. You will find some GRs, which is the governing regulation or government's uh, resolution passed from one department to other department, but which clarifies the process today, which kind of tries to at least give some clarity in respect of some of the interpretative issues on these various orders that are being issued. There are some rulings, there are some judgments and orders of the Supreme Court. Overall, in India, for business, there are at least about 690 such directives being issued. Now, government or let's say India legislatively is a function which is is a government that starts off with federal to state to local government, and therefore these regulations tend to be very complex at times. Uh, and our attempt today has been, how do you create a logical resource or repository of these so I call them the COVID-19 directives or directions, and try to understand what is law and what is not the law for people to follow. Because I think uh, we've seen some of the challenges going up to the court, where I think people are trying to decipher administrative rulings or merely advisory circulars, which is different from law, and a legal mandate which is being kind of mandated through a proper delegated legislation coming to us. So for any layman, forget about a lawyer, for even a lawyer it is very difficult, but for layman it's really very difficult today to decipher these directions and come to a conclusion what needs to be followed, what needs only an information there. Uh, this is again become very complex and compounded when we talk about fake news and fake directions. And I think I'm very happy that with Boom Fact Check, we've collaborated in deciphering what are the fake notifications that are circulating social media, that are circulating WhatsApp systems. They are not making life simpler, they're making life complicated. Just to give you an example, I think a couple of days ago the Ministry of Home Affairs in India had to issue a GR addressed to all the chief secretaries of the state, saying please do not believe in the circulars that are floating around to say that the CEOs of private companies will be arrested who do not follow the requirements of the lockdown and try to open their factories. I think it's a telltale story of what kind of fake news notifications, directions are circulating around. So, first learning that we have is that the communication and the information that gets communicated across various media today has to be looked at very skeptically from the point of view of what is fake and what is genuine. I think that's the first learning that we have. And we have almost 690 directions today that need to be understood in a correct manner. Some of the government actions, again, I must thank Mr. Gagan Singh for the kind of uh, picture that he's drawn here. This is relating to pothead and the flamehead, the two actions that India undertook. The entire nation came forward to clap or to kind of sound the utensils and to blow the candle outside their doors. I think thanks, Mr. Gagan Singh, for this expression. Uh, the government actions and the exemptions, when we talk about it, one of the most important one came from Reserve Bank of India. Reserve Bank of India on March 27, uh, as the kind of its capital policy came out with measures to combat liquidity constraints. And they said there could be reschedulement of payments, or payments could be rescheduled. Now, this is like a direction given or an instruction given to the bank to say that if you actually work around providing, or at least ease the working around the working capital requirements, the short-term financing, and the non-performing assets in a correct manner, we would probably look at giving you directions or instructions where there could be moratorium. That a borrower could be given a moratorium is also an issue, which is from the point of view of policy direction given to the banks, and then bank boards or board of directors of the bank being asked to make out their own policies. Now, sorry, this is not the law. This is direction given by Reserve Bank of India as a regulator to the banks. In the process, what happened is the special mentioned accounts which were under stress actually and were on the verge of being turned as a non-performing asset came back into the main fold. The time stopped probably from 28th of February onwards for the purposes of NPAs. So to that effect, the companies that were reeling under economic recession and stress moving towards NPAs today have got some breather. Secondly, if the bank agrees with or follows the directions of RBI, and most of the banks have done that, the banks have said that you can actually postpone your debt repayment, or this consider this as moratorium for the purposes of 3 months, April, May, June, and start looking at uh, starting the clock back again from July onwards. Although this moratorium does not mean that the banks will forego the the principal as well as debt repayment, the only thing that will happen is this will get postponed probably to the end of the tenure of your loan, and it will get added there. Uh, Therefore, from the provisioning perspective of the banks and their books and their accounts, there is very little impact during this financial year, because the special provisioning norms would now be permitted by RBI, as also the kind of regulator that talks about provisioning, which is the Institute of Chartered Accountants of India. The second thing that has happened in the process is not only the debt, which is the long term debt, but I think RBI clarified to say that short term working capital requirements, such as cash credit facilities and bill discounties, overdrafts, all of that, the repayments could be reset during this 3 months period, and therefore there is a rollover effect that can happen. That's possible. From an individual borrower perspective, this also means your credit card payments can be pushed by about 3 months. So overall, I think this moratorium that came on March 27th, of course, some of the directions relating to asset reclassification, whether the NBFCs were included, in a sense, whether an NBFC can go to a bank today and actually seek moratorium has been clarified by RBI. Yes, it is possible that NBFCs in turn can go to the bank. So whatever was the stress prior to COVID-19, I think that stress to an extent has been relieved, so to speak, for this 3 months period, insofar as debt markets are concerned, insofar as capital markets are concerned, and that has had its own effect, cascading down to the individual levels, even at the retail level. I think for the first time on April 17th, we got a clarification in respect of real estate projects. The real estate is another sector that's reeling under severe economic recession and crisis, couple that with COVID and lockdown. So these are some of the measures that have been announced by RBI. Ministry of Finance, I think first time on March 24th came out to say that we are extending all the due dates for filing returns, for payment of taxes, and for compliances, which also kind of included some of those extensions, some of those exemptions, which automatically got extended by a period of 3 months. With respect to payment of taxes which carry delayed interest, whether it is TDS to be deposited or taxes to be paid, I think the government came out to say that there will only be 9% interest levied on the delayed payments. So that's instead, otherwise it was 12% with cascading effect. I think 9% interest is like probably borrowing that much amount of money at 9%. Uh, Probably. And I think some of the Indian businesses will look at it as though it's a borrowing for 9% interest. On April 17, the government kind of issued a statement to say that large part of income tax refund which were clogged will be released. And to that effect, the government made a statement that almost 5,204 crore worth of income tax refund has been given to MSME sectors, and middle, small, and micro companies will get benefited by that. Almost about 1.74, 1.75 lakh cases are awaited for refund today, where there is a reconciliation to be done at ground level between the department and the assessee. And they're saying if this reconciliation activity is done, we are able to give you that kind of a refund. There is a direct benefit disbursements that have happened through DBT mechanism in individuals' accounts worth almost about 36,659 crores. I think that's a good sign insofar as those people who actually are in unorganized sector. They're probably migrant workmen. They're not in the organized sector. They are covered under that scheme. In their account is the statement that came from the government on April 19. Also, I think what Ministry of Finance did was they've frozen the dearness allowance for the government employees, and therefore dearness allowance for government pensioners as well. So freezing of the dearness allowance, because probably most of the government employees are also either working from home or they're remotely available. So this is one kind of a directive of Ministry of Finance, which today will be challenged, or even the private sector is looking at saying, if government is going to freeze the dearness allowance, I think our obligation for our employees is not to give them such allowances which are work related, or where these allowances were in the nature of going to the work and coming back from work. Of course, incidentally, a super you know, international financial services super sector regulator has been notified on April 27th. Probably that has nothing to do with COVID. It was a normal business as usual for the government. We're looking at Ministry of Home Affairs and Ministry of Corporate Affairs, and a little bit of piece in between there from Ministry of Health. Again, this picture is from artist Miss Rani Rekha. Thank you very much for giving us this picture during COVID-19. It's very expressive. It's an interesting picture. So when Ministry of Home Affairs, I think, came out with guidelines for the purposes of lockdown. Now, lockdown is an action which the lawyers will look at it from a force majeure perspective as a government action, and I'll talk about it a little later. Therefore, March 24th, the consolidated guidelines were issued, and they have been modified virtually from time to time, again and again, because the modifications were required not from the point of view of clarity of thought, but from the point of view of experiences that came forward during the working of lockdown. And I think tremendous tribute has to go to Ministry of Home Affairs for constantly clarifying and modifying these guidelines and coming out with clarifications which were well required and desired. As a lawyer, therefore, it becomes essential when we talk about force majeure, or when we talk about what was the situation on, let's say, March 31st. I think we have to look at the things, and these guidelines, these consolidated guidelines as they have moved from time to time, are very helpful for us to understand the situation. Secondly, for a slow release of the lockdown into the green zones that have been created by Ministry of Health, I think the Ministry of Home Affairs has actually issued standard operating procedures, and an extremely good job has been done when they adopted SOPs that were laid down by WHO, that were laid down by international agencies, and they've indigenized this based on the experience. In preparing and implementing the SOPs, the government has actually club together, work together with various chambers of commerce, trade institutes and bodies to make sure that their concerns are included in the SOPs. Uh, I mentioned very briefly earlier that on April 20th, a DO letter was issued by uh, the Ministry of Home Affairs to say that don't arrest CEOs of private sector because there were these fake notifications doing the circuit. There were rumors that if somebody opens up a factory in green zone, I think the district magistrate has a right to arrest those CEOs. There were news atom to that effect. Some notifications which were fake were being circulated. I think kudos to Ministry of Home Affairs for doing this right and issuing this from time to time. uh, Ministry of Corporate Affairs, actually, a very simple compliance was sought for from the companies to say that the company's affirmation of readiness for COVID situation was asked for. All you had to do is file a self declaration or affirm yourself that we are ready for COVID-19. What this did to the companies is while they were filing these confirmations, I think it became imperative that as a business continuity process for each of the companies to look at their own systems, to look at their own readiness, right from whether it is a digital readiness to work from home to 50-50 formula where 50% of the workmen in essential offices category were asked that they may come to the office. What was the readiness of the company? They actually started looking at business continuity process and got this right. Government came out and they have actually extended time where the dates were expiring during this period. And mind you, March 31st was actually a financial year closure for us. So there were many compliances that fell around March 31st or within 1 month from March 31st. We seem to have got this right in terms of granting extensions to the expiry dates, granting extension to the compliance times, granting extension to some of the exemptions that were enjoyed by various companies under various laws. I think they have been automatically postponed. That's a good sign. Um, it kind of just reduces multiplicity of litigation as we move forward. Again, I think whether it is annual general meeting, whether it is extraordinary general meeting of shareholders, whether it is meeting of board of directors, whether it is meeting of independent directors, meeting of committees, what was required, even in couple of instances, as a physical meeting, which necessitates, some of the items of agenda cannot be taken by digital meeting. You need a physical meeting to take place. Like, for example, adoption of accounts. I think those kind of compliances and those kind of meetings have been substituted with digital meeting. This has helped a lot. Also, from the point of view of requirement of residency status of the director, I think that's been dispensed of. The 210 days period where the resident director or non-resident director ought to be in India, that's dispensed off with currently. I think that's a good sign there. The CARO, which was to come from the financial year 2020-2021, that's been postponed by another year, which also, to an extent reduces the pressure from the auditing community and account related issues. The debenture deposits which were required to be created, that's been dispensed of till June end. So those are the debentures that mature during April, May, June, need not really create a debenture deposit and the reserves in advance. They can start looking at it, creating it till from June end onwards. So to that effect, there's not that much of pressure on the liquidity insofar as those companies that came out with debentures. One of the very important things from compliances perspective is that there is a company's fresh start scheme that has been announced. So in past, whenever there has been defaults by the companies in terms of its filing of various returns, including accounts, including financial statements, for 3 years, that resulted into disqualification of directors. I mean, all these anomalies have now been removed, and the government has come out with the fresh start scheme for the companies, which will also include also for the limited liability partnerships and partner LLPs and companies, where you can actually consider cleaning up your accounts during this period, clean up your compliances, pay some fines, and move to restart your company and restart your corporate entity. So these are some of the government actions and exemptions that have come during this period. As I said, again, one more caveat that I must kind of repeat: this is not an exhaustive list. Also, in between all this, there is Arogya Setu there. That Arogya Setu is an interesting app that has been developed to an extent. Companies are saying, or people are saying, that you see, this Arogya Setu will be very, very helpful in tracking the health of individuals who are going to workplace as the lockdown gets released. Uh, from that perspective, plus tracking your own health, each and every individual and citizen of India can today download the app, and it's a very interesting app. There are a couple of concerns being raised around this app with respect to data privacy. That's been clarified by government and Ministry of Health Affairs from time to time to say that no, this is fully compliant and it's secured in terms of your personal data. Okay, now when we come to legal issues, and again, I must thank Arjun Das for this very interesting kind of art here, interesting depiction of what everybody is trying to do is to make sure that you stay indoor and Corona is outdoor. Uh, the coronavirus is outdoor. So from that perspective, I think thanks to Mr. Arjun Das. Arjun Das is, in fact, an artist from Jamshedpur. Very interesting art connotations he has. So I think we come back to the legal issues and the contractual implication, because everybody talks about pandemic as a force majeure event, and whenever uh, legal issues are being talked about, uh, there is no talk without the force majeure there. So we're saying, of course, force majeure has been declared. COVID has been declared as a pandemic by WHO. WHO, I think first week or middle of March, somewhere on 12th or 14th of March, declared uh, coronavirus, the new coronavirus disease, as pandemic, and as it characterized it to be a global pandemic. So to that effect, it qualifies to be a force majeure. Prior to this, when I think in Wuhan and in China, uh, coronavirus was detected and became rampant, it was considered as a local force majeure, and to that effect, China's commercial authorities issued the force majeure certificates to Chinese companies, which 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 was one of the requirements in most of the jurisdictions, to produce a certificate which said that this is a force majeure issue. So that certification would now not be required, because once it's declared as a global pandemic, the factum of whether this amounts to force majeure or not, this amounts to act of God or not, is is therefore doesn't need a proof like a certification proof. Otherwise, from local chamber of commerce, I think each businesses was required or were required to procure these certificates. That's the effect of WHO declaring this to be pandemic. Now, force majeure is not a codified law in India, except in some legislations like the real estate RERA legislation. We don't find reference of force majeure as a statutory protection. In enactments such as RERA, I think it was mentioned that one could actually make an application of a force majeure to say why your project got delayed. So, except for such statutory reference in RERA, we didn't see this as a codified law in India. This remained as a practice, a common law derived, but there is a provision under Indian Contract Act under Section 56, which talks about impossibility of performance of the contract, which gives rise to whether a particular obligation perform to that effect can be excused, or under what circumstances it is not excused. So that's section 56 under Indian Contract Act in reference to impossibility of performance. Now, what happens is that it reflects and it goes down to section 65 of the Indian Contract Act, where there is a restoration of advantage to somebody where the performance obligation of the counterparty is impossible to perform. So actually payment of advance towards an engineering project would fall as a perfect example within section 65, where the persons who paid you an advance would now be seeking refund of that advance if it terminates that arrangement and terminates the contract. What's true for an engineering contract is true for various other contracts, including the contracts between producers and distributors in the retail sector, including the loan licensee manufacturers. And therefore, there are various such scenarios that would emerge, which will lead from section 56 to section 65 on restoration of advantage with respect to the COVID-19 situation. Of course, force majeure is a provision which many a times you find in the contract itself. So it's a contractual relief. So we have to really understand the interplay between frustration of contract, which is section 56 leading to impossibility of performance, and the force majeure, which is there in the contractual provision. So these are complex issues. So very simply put, you can't really say that force majeure is now triggered because there is a COVID-19 and a global pandemic issue, and therefore my obligation stands abrogated today. That's a very simplistic stand to take, but it may not survive the legal scrutiny. Okay, now what is the force majeure? And that's where we'll look at bit of what is this event that will qualify to be force majeure. Again, I must say thanks to Dhruvi Acharya for giving us this art form, this painting. It's act of God. It's act of God as a part of the force majeure. So many a times the definition of force majeure in a contract, had words like, an event such as an epidemic, an event such as an act of God, even such as a natural calamity, and even such as events such as government action. It also says as an omnibus provision or general catch-all provision, which says events which are outside the control of the parties. That also falls within the ambit and within the gamut of force majeure. So therefore, now let's look at COVID-19 as an outbreak. It's qualified as a pandemic from WHO, so it qualifies to be an epidemic. In the National Disaster Management Act, this has been considered as a disaster, where epidemic may not be specified as a part of the force majeure clause. You may probably have umbrage against act of God, because this is neither of the counterparty's responsibility with respect to act of God. Is this natural calamity? The answer may be no. But if you look at the National Disaster Management Act, we do not know whether it get in there. The government action, of course, COVID-19 per se will not be government action. Lockdown would be governmental action. And if you take shelter under governmental action, the lockdown would mean different things for different people at different locations. In a sense, the first distinguishing factor that government did is essential versus non-essential services, essential versus non-essential businesses. And to that effect, therefore, government action will apply differently to different people. Again, I think while releasing the first phase of lockdown, government also looked at releasing in step-by-step manner. So the financial services, some of the NBFCs, some of the definition of essential services was amended and modified from time to time. So to that effect, whether that government action applies to you or not will also depend from fact to fact, case to case. The second aspect is this differs from location to location. Some of the locations like Mumbai and Pune, for example, have not only, there are declared lockdowns across the towns and municipal localities, but there are some of the areas which have been completely sealed. The sealing has been ordered. So to that effect, the lockdown enforcement is stricter and sealing has happened. Uh, Therefore, I think the government action, if you look at force majeure as government action, it will apply differently to different people. And of course, under the catch-all provision, you can always take an umbrage to say that this event, which is the COVID-19, as also the government action of locking down, as also sealing of the premises, all of these are events which are beyond the control of the parties, and therefore that qualifies to be a force majeure event. Uh, so from the point of view of COVID-19, what is it that you would want to take, and where do you fall, or where does your case falls, is an important element to be looked at. There are certain challenges, and again, thanks to this mural depicting. The challenges are actually from the point of view of features of the force majeure clause. While you look at the definition and see where you fall in, you have to also kind of prove that this is unforeseeable. I never saw COVID coming. That's very critical as a piece of claim that you make, or your contention there. You're also saying that this cannot be mitigated, and therefore duty to mitigate this is also cast upon person who claims the relief of force majeure. Now, this duty to mitigate, very simply put, if I just came across a case where one of our clients, foreign partner or foreign client of our client, who had actually given an infrastructure project contract, came back when Indian client wrote to him saying that, no, this is covered under force majeure. I think the counterparty wrote back to say, sorry, I've given you advance. Your first obligation was to prepare design and drawings. We believe the lockdown in India does not prevent you from preparing these designs and drawings. And I think, therefore, you will have to demonstrate your duty to mitigate by showing it to the counterparty that you asked your employees to prepare the design and drawings while they were working from home, and they kind of replied to you saying, sorry, we can't prepare these designs and drawings for various reasons, probably including lack of infrastructure, including lack of input, why they were not able to produce these designs and drawings. So that, in to an extent, duty to mitigate will be discharged if you are able to shift your onus of proof and shift your burden to say, sorry, I took all the care to make sure that whatever was possible from my side, I've tried to do it. Despite of this, it's immitigable circumstances, and therefore I claim force majeure. Of course, the burden of proof on the force majeure is for the person who claims the force majeure, but it's not as easy to claim a force majeure, because the counterparty would actually get a right to terminate your contract. Counterparty would actually get a right to ask for restoration of advantage under the contract. So while you may want to extend the time, you may want to say that I want to suspend some of my contractual obligations, but you have to be careful in terms of what does this do qua the counterparty. Because in certain circumstances, you would also be the counterparty trying to take advantage of the force majeure and the legal situations. Again, thanks to Ms. Dhruvi Acharya for this very, very illustrative art here, illustrative painting here. What is the legal response that the businesses are today deploying as a response to the pandemic? Having looked at what is the legislative mandate, or what are the government actions, what constitutes force majeure, and how that fans out in a contractual manner, what are the legal responses that people are taking? Of course, and these legal interventions are critical, because I think health is a priority. Today, people are not only looking at health as a matter of duty, but I think most of the corporates in India are looking at health as not only the priority item, but it's being looked at from a compassion point of view. Earlier scenario, I think there were health insurance that companies had, but no longer the companies are relying on only the insurance as a fallback mechanism. They're willing to go out of pocket, They are today willing to support their own employees through the earlier kind of a disasters and economic recessions. I think what companies have realized, and by and large, most of the creditable companies in India are looking at this issue from a compassion perspective and saying that the health is more important. So we will give you that security from the health perspective. Excuse me. We also look at mental health as one of the areas in which we want to keep our employees strong, because retaining talent is retaining muscle for the future business. So I think health has become priority. From that perspective, I think the legal responses that have come on board is predominantly by the insurance companies. See, the insurance companies very clearly have come together, at least the life insurance companies in India have come together and have actually declared, saying we're not going to reject any claim arising out of COVID. Of course, the life insurance would depend on where the deaths have occurred. But I'm sure the medical insurance and non-life insurance companies will also follow the suit. They're saying we will not uh, reject any claim because there could be force majeure clause in our policy, which force majeure clause would cover an epidemic for us to deny your claims. But I think that all of them, they came together to say that we are not going to deny these claims arising out of COVID. So a very clear table has been set by the life insurance companies today, very early in the game, to say that we have a force majeure clause under the COVID, under the global epidemic, we can reject your claim, but we're not going to reject your claim. We're not going to take umbrage against under force majeure. We will continue to honor your claims. I think that is the compassion that is getting transferred across most of the corporates in India today. The second element for legal intervention is, of course, the finance. And I think one very critical element that came out from the RBI directions is the moratorium. And I think most of the Indian corporates and Indian companies have taken the moratorium. There are, as we speak, more than about 356 companies that actually took moratorium, and they include most of the large companies in India. Uh, so that's one area in which the companies have looked at preserving the cash. Now, what does this do to your legal documentation, which is your loan agreements uh, and the covenants therein? It actually suspends this period of 3 months as a moratorium. It doesn't require any innovation to the contract, is what we hear. It doesn't require any amendment to the loan documentation. It just is by way of request being made and request being accepted. Request being made by the borrower to the lender, lender accepting that request. I think this moratorium is being effected in that manner. See, when we talk about employees, I think retrenchment of the employees under model standing orders, the central as well as some of the state model standing orders, and these model standing orders varied from state to state, and their understanding varied from company to company as well, because some of the companies got into certified standing orders rather than model standing orders. So there was nothing contemplated in true sense directly covering the situation such as pandemic. What was covered was stoppage of work due to epidemic and then retrenchment by the employer. Retrenchment can happen with or without notice. And in the normal things, probably the employers would have retrenched because they're unable to get work from the employees. I think Ministry of Home Affairs actually issued that notification to say that, sorry, you cannot today under COVID circumstances and lockdown circumstances, you cannot retrench people, you cannot lay them off, and you have to continue to pay them wages and salaries. We'll come back to that as to what's happened there. So that's one area where I think the law is different from actual practice. What's happening is that people are saying, yes, these are our employees, these are our people, they're also going through tough times. We will try to accommodate them. Some of the companies that have ability to pay have completely paid to the employees. Some of the companies are struggling, and most of the companies have actually looked at varied pay being given to the employees depending on their structure, depending on their wage structure, depending on their organogram. And But I think one thing which is commonly emerging is that except for few companies that have said we will retrench people, I think most of the companies are looking at not retrenching their employees because of COVID-19. That's an interesting and a good sign there. There is a deferment of tax that almost every company has availed to actually obviate short-term liquidity and short-term cash flow issues. This deferment of tax is considered today as borrowing at 9%. And we will come back to this when we look at international transactions. How does borrowing at 9% look like? You know, there are some companies who have actually said we are going to defer payment of salaries. Uh, we're not going to retrench you. We're not going to deduct your salaries. We will defer your salaries. Like the government has actually stopped the dearness allowance. Is that's something different from deferment. They have actually said that the government employees will not be entitled to dearness allowance, and the pensioners will not be entitled to the dearness allowance or enhancement in the pension from January 2020 onwards. It's interesting to say how the courts will look at it. Okay, invocation of force majeure clause as a kind of a legal response. I mean, you can look at invoking force majeure provision if it is there in your contract to the extent of terminating your contracts. At times, you'll want to look at suspension of the period, or you want to look at deferment of payments by invoking the force majeure. So there are various options even available even within the force majeure, and I think that's a legal response. We will see a lot of variations coming out of it. The compliance is becoming a new norm for the simple reason that one of the consequence for not adhering to the standard operating procedures or the compliances today is resulting into shutting down of your establishment for another 3 months. You see, the consequences specified by the government today on the slow release of the lockdown and bringing your establishments back into the business as usual is that if you falter on the compliances, you will be shut down for another 3 months. That is pushing it. It is a consequential approach, but it is resulting into stoppage of business and business continuity coming under different pressure. Although the Ministry of Home Affairs has said that we will not arrest the CEOs, I think penal provisions have been mentioned as a consequence. Therefore, compliance is becoming a new norm, and I think when the government says, according to the lockdown release guidelines, that you need to make sure that there is a 6 feet distance between two employees, I think the employers are taking this very seriously because your business continuity depends on these kind of norms and standard operating procedures. You know, various people are altering their priorities, and the sanctity of contracts is coming under stress today. When we say sanctity of contract is coming under stress today, I think while you may excuse performance of obligation because of the force majeure, you may suspend certain obligations into the contract, but you have to adhere to the contracts, and you have to look at sanctity of contracts as one of the very critical area of your legal response to COVID-19. You know, this is resulting into altering business relationship. Again, thanks to the artist or series of artists, this is a street art during COVID-19. Um, it's very illustrative, and it actually looks at things in a bright perspective insofar as Indian situations are concerned. Thanks for that art, please. Uh, I'm saying the business relationships that are coming under stress are manifolds. When we talk about parent subsidiary, if you have, let's say, a parent company in Singapore and a subsidiary in India, or you have a parent company in India with a subsidiary in Singapore, you see, insofar as listed entities are concerned, the fall in share prices of subsidiaries at the March end, especially year end, is resulting into a tremendous erosion of net worth of your subsidiary, which in turn is resulting into capital interventions that are required. These capital interventions would take many folds. That's one area of stress today. The transfer pricing by multinational companies coming under stress today, because you're talking about sanctity of contract, but here is something where there is a parent subsidiary relationship coming under stress, and under the extraordinary circumstances, you'd probably require uh, different measures insofar as capitalization of or even supplying of the goods, supplying of the services are concerned. That forms part of the transfer pricing issues. Okay, the expat employs the governing rules with respect to their employment. I think suddenly is taking a new turn. We've seen couple of service conditions, uh, especially for US expats, where the things are now looking brighter to say that I'm governed under Indian law rather than being under US law. So I think the governing rules relating to the expat employees is taking an interesting turn, so to speak. Okay, advanced pricing agreements. Some of the multinationals have gone back on the advanced pricing agreements and said we are terminating the agreement. Some of them are looking at suspending these agreements, but advanced pricing APA mechanism is putting various subsidiaries in India under stress again today. The resident director's residency requirement of 210 days has been diluted. So to that effect, if some resident director is already abroad, he need not come back. Is unable to come back. That's not considered as a ground for automatic vacation of the office of directorship. It still is continues to be compliant. The FCRA regime is also forcing the subsidiary companies today not to donate anything or not to kind of embark on CSR funding, because that is considered as indirect foreign capital wherever there is a parent subsidiary relationship. Sorry. Thank you. I think when we talk about joint ventures, of course, liquidity and capital funding, like in the parent subsidy situation, will continue to be a very, very challenging space currently. The cash flows have dried up at both the ends. The cash flows have dried up with both the partners. And where are you going to get your capital to be funded from? There is a skewed equity capital that is required today for you to keep the joint venture company afloat. uh, that's where the problem arises. Most of the joint ventures were driven by the business plan, and the control of the joint venture was with respect to joint business plan that both the parties drew together. That's that's of course the business plan per se has gone out of the window. Um, there are no plans that are surviving at least for first 2 quarters of this financial year. So from that point of view, the controls have moved. The business plan is not um, kind of driving the controls any longer. In some of the joint venture where there has been deadlock, I think deadlock risk has evolved, and the deadlock resolution is necessitated today. The deadlock has arisen. So there was economic recession, then there is a lockdown, there's COVID-19 situation, and now you have the joint venture deadlock as a situation. Is becoming tough for joint venture companies. We have experienced a couple of ownership buyouts that have happened during this period, but those buyouts have been distressed buyouts, distressed from the point of view of seller at times, from the point of view of buyer at times. And now and again, we are asked to look at doctrine of necessity. You're saying uh, the joint venture businesses where one partner is taking time to decide whether to do the fundraise or to kind of do the capital raise, whereas the business requires today for payment of salaries, for payment of various outgoings, some amount of money and liquidity which is not available. I think therefore doctrine of necessity is being uh, invoked, and or we're being asked to look at that issue from a legal point of view. Bilateral investment treaty between India and Singapore, that was already terminated in April 6, 2017. So therefore, question of uncompensated expropriation being an individual investor's claim under the bilateral investment treaty is not any longer questioned today. Of course, invocation of doctrine of necessity is taking a different turn. It will result into few of these adjudications going across in a dispute. Okay, some of the other relationships that one needs to look at, and thanks to I think French artist Legros. This is actually graffiti on grass. This is with respect to biodegradable paint that he created. And when you take an aerial picture from Swiss Alps, it looks fantastic. And this is actually done during the COVID. Um, I think the artist Legros has various such graffiti on grass as his project. Uh, Okay, from a lender borrower perspective, I think we've looked at availing moratorium. We've looked at force majeure, but force majeure does not, as a general rule, apply to the financing documents, and therefore, to that effect, I think there is no force majeure when it comes to lender borrower relationship. That's a general rule. The specially mentioned assets, the SMAs, SMA 0 to SMA 3 was a pendulum. When an asset became SMA 3, it became NPA. That pendulum has been stopped, and specific directives have been issued by RBI to the lender banks to look at SMA 0 to SMA 3 as the suspended regime during this period. What this really means is that people will, even if they don't pay a single rupee towards their debt repayment, either interest or principal amount, uh, the SM, it will not be considered a specially mentioned asset. You will not move towards NPA even after 3 months, or it will probably take another one more quarter before you actually move towards NPA. So actually a 6 months moratorium period is what you would probably enjoy in this space. As I said, there are almost about 328 large companies that have availed moratorium today. Certainly, we've seen India's overseas borrowing going to almost about $45 billion. That's because probably it's a difference in interest rate today. And FCCB norms, even those norms were diluted by RBI prior to COVID-19. So we have seen a different lender-borrower relationship emerging from here onwards. Very interesting kind of relationship that is emerging. You see, many a times the landlords are saying we have a security deposit and we will adjust this 2 months or 3 months rental towards the security deposit that's lying with us, because that's what was the obligation. And post-COVID, I think they will come back to say that you replenish your security deposit. I think tenants need to be ready about it. Most of the people who actually falter is to take umbrage against force majeure when there is no provision in your lease deed. I think that's totally wrong. What takes priority is actually Section 108 of Transfer of Property Act. And that's where the landlord-tenant relationship gets covered. Secondly, we have to tread very carefully in respect of landlord-tenant relationship and force majeure and allied issues. Because I came across a very interesting judgment, and thanks to a couple of my colleagues, Basuri Swaraj and Siddesh Kotwal, who brought to my notice. There was very interesting land lease, agriculture and land lease related issue that was decided by the Supreme Court in 1968, where the part of the land for which the tenancy was created between two parties who were in India, it went in partition to Pakistan. And they said, now that the land is not available, it's none of our fault. It's act of God. It's kind of a force majeure. There is impossibility of performance. Actually, it's an interesting reading, that Supreme Court judgment. It says when it comes to land and lease related issues, if you're asking for refund of your rent, okay, this is not the event that is contemplated to be covered for saying that the land is not available now and therefore I can't cultivate it and therefore I need my rent back. They said this is not the case. A very interesting judgment. And I think therefore landlord-tenant relationships will undergo a different change from the force majeure contractual relationships. Of course, employer-employee relationships are there are contractual employees and there are statutory employees. There are workmen and there are contractual employees. So from that perspective, I think the matter is currently before Supreme Court insofar as statutory workmen and statutory employees are concerned. We are awaiting Supreme Court decision. Very clearly, the logic is that they've challenged the Ministry of Home Affairs circular that kind of talked about asking private companies not to retrench people and continue to pay them salaries and wages during the lockdown period. This was issued under the National Disaster Management Act, and whether it constitutes good legal document or good authority of law or not is the question before Supreme Court. Maybe another about week to 10 days, and we will know where we stand with respect to these relationships. In the meanwhile, my advice to the clients have been that please pay whatever you can to accommodate them and consider it as an ad hoc payment. uh, of course, when it comes to non-statutory employees, I think there is a very clear fundamental of universal basic income, and this principle coming forward, where people are saying that I need X amount to sustain myself during this period. So rest of the salary I'm foregoing for a while, and so that company can utilize that cash, conserve its cash for payment to other employees and survive in the business. So it's a very interesting kind of phenomena that's emerging based on universal basic income principles. Okay, the new business relationships are also kind of giving rise to new revenue models. Again, I should thank Sudarshan Patnaik, uh, the sand artist from Orissa. Again, it's a very interesting and very clear depiction, and it's 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 a sand art. Uh, so thank you to Mr. Patnaik. Uh, you see, the new models which are emerging with every business, there is an innovation happening today, uh, where work from home is resulting into uh, actually digital space at one hand becoming very, very challenging from the perspective of compliances, governance, data privacy, because I think cyber attacks are on increase, and they will continue to increase manifold. Every other day, we are getting a scare about cyber attack. We are getting new malware attack. And I think therefore digital space is becoming very, very challenging to work on. But there is no option, because work from home is resulting into people working in the digital space today. The legal regulations that have been issued, although some of them are not in the nature of regulations properly issued under delegated legislation, but still administratively they are helping the business objectives to be aligned with the regulations, which otherwise was a problematic issue in the Indian situation. Of course, I think we see that post-COVID, there will be mediocre businesses will not survive. It will be businesses that are fundamentally very strong, uh, businesses where innovation is to the forefront. Those are the businesses that will survive. We are also looking at collaborations across the boundaries, and these boundaries and jurisdictional limitations will not come in the way of people finding a way to work together. Like, for example, the, the pharma companies coming together to make sure that the medicine for coronavirus and uh, the inoculations that are required for coronavirus will be shared across everybody, because we'll require massive amount of manufacturing capacity. Post-lockdown, people are looking at uh, turning material adversity into unprecedented opportunity, and that's where I think innovations are coming virtually on a daily basis. There are innovative businesses that are coming up. We, as I said earlier, we probably look at new legislation coming in, which is COVID-19 code being talked of today. Whether this will come in with retrospective effect or not is a question mark today. What will we see as we move forward? Because I think the relationships are coming under stress, the legalities are coming under stress. Uh, would we see disputes? In fact, one of the lawyers, uh, and there are law firms who are predicting that there will be tsunami of litigation after the COVID uh, lockdown opens up. We are also seeing there are lots of thought leaders who are articulating today that there is no option but to mediate, conciliate, create forums such as ombudsman, and collaborate across various people. We will see some holy alliances emerging from here, the worst of the competitors coming together. And I think to that effect, the Competition Act and anti-competitive laws have taken a backseat, and they have kind of come out with some standard operating procedure as to what do we do You need to collaborate together, but what are the standard operating procedures that you need to follow in these difficult times? So I think while some are predicting that there will be tsunami of litigation, most of the people believe that there will be conciliation, mediation, and collaborative approach that will give rise to the new world. Again, thanks to Gary and his project, we have seen hope. We have seen hope from various quarters, but one hope which comes is from judiciary. And judiciary, the manner in which judiciary is behaving and the judicial trends are looking at today, at least in Indian context, I'm of the view that it's a place which will define hope. The courts have become virtual places today. What we were fighting for years together, bringing in technology to the courts, I think COVID-19 has done it overnight. They've converted some of the courts into video conferencing rooms and some of the proceedings into video conferencing proceedings. Uh, I have a feeling that that is there to stay. The video conferencing is there to stay, and the justice dispensation system and the delays in justice delivery system would now be looked at from the point of view of expediting the matters from uh, virtual digital spaces. Electronic filing has already been made mandatory. There are all the currently the courts are um, you know hearing only urgent cases, but as the lockdown starts getting released, we will see a lot of changes in this space. Uh, Currently, all the stay orders and injunctions that fail due within the lockdown period are being automatically extended beyond lockdown. There are about 46 orders and judgments that have been issued by various high courts and the Supreme Court of India. Some of them, they relate to invocation of a bank guarantee being stayed. Some of them are interpreting government measures with respect to, let's say, COVID tests to be carried out. Uh, One very interesting judgment that came from Bombay High Court was relating to the share pledge. UBS actually invoked a share pledge qua one of its borrower from Future Group when the markets tanked and the share value plummeted down. Uh, that action of UBS was seen by Bombay High Court as a very opportunist action during COVID period when everybody's shares hit the rock bottom. Uh, Bombay High Court actually stayed the invocation of the pledge of promoter shares there. Uh, this has been confirmed by the Supreme Court saying it's merely an interim relief. Therefore, the matter would be heard on 4th of May. We will start observing and looking at these court behaviors and judgments from the point of view of how the legal situation fans out in India. I would say thank you very much for patiently listening to me. I would be happy to take some of the questions if they're there. Um, I'm extremely
Thank you so
sorry if it became repetitive and boring at times. My apologies to that. But please go ahead. If there are any questions, I'm happy to take them.
yeah, thank you, Suhas. If anyone has question, you can raise your hands and I'll unmute you. Suhas, we have two questions. One is from can no work, no
Sorry, go ahead.
Can no work, no pay calculation be applied for calculating salaries to workforce engaged in essential services?
Sorry, I didn't get you there, please.
Yeah, I'll repeat again, Suhas. Can no work, no pay calculation be applied for calculating salaries to workforce engaged in essential services?
You see, it would all depend on whether whether your establishment is a manufacturing unit or a commercial unit. Again, if it is a commercial unit, where is it located? If it is a manufacturing unit, where it is located, and for what period of time? So there are these kind of variables that you will have to look at. So the fundamental principle, no work, no pay, if that is part of your uh, condition of work, like for example, if it is part of your model standing orders and your model standing orders read that way, then yes, definitely you can apply the principles of no work, no play, no pay. I'm sorry. But again, I think the jury is out qua the order issued by the Ministry of Home Affairs under the Natural Disaster Management Act. And my view would be don't take any final view till the Supreme Court matter is decided. Does that kind of answer the question?
Suhas is from anonymous attendee. So,
Okay.
yeah. Second question is from Ramesh Sharma. If there is no contract and the force majeure clause is not included in an agreement, can it be taken advantage of in the light of WHO declaration of COVID-19 as a pandemic, particularly with regard to payment obligation of available services? Ramesh Sharma is Executive Director of Legasis. So,
Yeah, I think it would again depend on the facts of each case, but a short answer to that is yes. If you are able to demonstrate its impossibility for you to perform obligation under your contract, yes, it would be possible to claim a relief from the performance of that particular obligation. Although avoiding the entire contract may not be possible. Yeah, does that answer the question?
Ramesh Sharma sir, I've allowed you to speak. Yeah. So he's not able to.
Okay.
We'll go to the next question. Kaustubh has a question. I'll just allow him to ask. Okay, Kaustubh, you can unmute and ask.
Yeah, thanks. I mean, I've had a couple of questions about the whole advisory situation that's been issued by the Ministry of Home Affairs. Firstly, what would happen, in your opinion, what would happen to people who are working for aggregators like Ola and Uber? I mean, there's no requirement for their companies or Uber or Ola to pay them, right?
It would all depend on it would all depend on what your contract is.
Okay. Okay.
You see, it's not that there's no obligation to pay. I mean, if your contract creates an obligation to pay, despite of whether your vehicle is engaged or not, then I think that obligation would survive. If the obligation is that you will make the vehicle available, and if let's say the driver or the owner of the car is making that car available, and then Uber is not able to provide the business for no reason of Uber as well. So I think I'm sure if you look at and read between the lines of an insurance contract for Uber business, you may find a couple of answers there.
No, because I mean, the question first came to me when I was looking at the requirements for businesses to pay their employers, and it says wages instead of other payments. So based on that, I'm guessing allowances and bonuses that Uber is contractually supposed to give are not included, whereas the commission that they charge is part of the wages. So I mean, I guess would have to look at the contract.
Yes, you'll have to look at the contract.
Yeah. So my second question is more about the policy itself of requiring an employer to pay, and what would happen in the case that tomorrow if the Supreme Court decides that no, the government has to subsidize some part of this payment. For example, I think one of the petitions is for subsidizing 70% of the payments that MSMEs have to give. So if that judgment does go through, and if the government is required to subsidize these things, would that be something that could possibly continue? Because I mean, I thought of this when you mentioned the universal basic income aspect. And is that something that could continue, or, more likely will it only be for this period?
No, I think my reading or my take is that at some point in time, government will have to come out with a legislation that would deal with most of such situation as to how long, if at all, these subsidies have to be paid by the government, for how long will they do it. For example, in the US currently, I think they have asked the companies, especially from SME sector, to actually draw down subsidies for payment of salaries and wages to their employees for the period of 3 months. There is a clear subsidy scheme that has come up. It's besides the point that there are some of the companies have actually, who are large companies, have actually made applications and got themselves benefits out of these schemes, and there is a huge kind of controversy that has emerged. But just if you were to look at the US example, and that may not be the best example to follow at this point in time, but that's an indication of the fact that subsidy schemes will themselves define the period for which these schemes and benefits would be available.
Okay. I'm sorry, is it okay if I ask one more question?
Sure, sure.
Yeah. So there is the advisory of 29th March, which says that, we have to pay, employers have to pay their employees full wages on time. Before that, on 20th March, there was one from the Labor and the Labor Ministry, which said that you have to, of course, you have to pay, and you can't terminate your employees either. So I feel like there's a lot of concern going on about the 29th March advisory, and some of the opinions that I've seen and some of the views that I've heard of have said that, instead of paying your employees, it'll be safer if you, in fact, furlough them. But I mean, according to the legislations that I've seen, the enforceability of either of these advisories is, I think, on an equal ground. So would you actually advise someone to consider both of these on equal footing, or is one more relevant to look at than the other?
See, if you look at the fundamental theory of interpretation of laws, I think the subject matter of payment of wages would be closer to the Ministry of Labor than the Home Affairs, although the disaster would be considered as closer to the Home Affairs. And therefore, if you look at the circular issued under the National Disaster Management Act,
right,
there's a non-obstantive provision to say that, notwithstanding anything inconsistent with any other law, this law will prevail. I think the later law will prevail over the earlier law. If you look at proximity to the disaster, and the Disaster Management Act would get covered, then I think the circular of Ministry of Home Affairs will have an overriding effect over Labor Ministry, because they are currently inconsistent with each other in a sense. So,
okay.
but however, one doesn't know what the courts will courts will look at and what stands the court will take.
Yeah, that'll be interesting. All right, that's it. That's it. Thank you.
Suhas, I've got one question from Colonel Chandok, who's actually on YouTube because he couldn't access the webinar. His question is that the guidelines issued by the Home Ministry, are they applicable only for blue-collared workers, or they are also applicable for managerial and white-collared employees?
Yeah, I think Mr. Shivprasad and Colonel, I think those are applicable to almost everybody. The Home Affairs circular does not make any distinction.
Actually, Suhas, I've got one point. In one of these circulars, it was very clearly mentioned that it was applicable to migrant workers. So is the government's directive actually supposed to be payment of wages mandatorily for migrant workers, and it's been interpreted that it's applicable to all employees? Is not that a moot issue which is now going to be considered before the Supreme Court?
Yes, I think there are interpretative issues, and therefore, if you look at the manner in which Home Affairs has been amending their own circulars virtually on a daily or alternate day basis itself creates and raises issue on the interpretative value of those circulars, whether it is law or not. That's the first thing that would get argued, and that's getting argued today. And if they have issued these orders, unlike what I mentioned to Kaustubh on the rules or law relating to interpretation of statute, I think more importantly, if you look at whether the particular circular and order is ultra virus the object of the act or not, I think that's a larger discussion that will take place uh, before the court. From that perspective, I think what you are saying is also quite clear. I think if you look at the migrant workers, I think the migrant worker situation, there is already a cess that used to be collected by the state governments. The BOCW as a cess for building workers, that was collected by the state government. The minor mineral cess was being collected by state government. And if you recollect, the finance ministry's one of the first press circular or press note talked about this amount of money under to be utilized for migrant workers. The mining cess collected by the state governments to be utilized for migrant workers' benefit. So I think today, while on the administrative side, there seems to be this war of the turf going on, from the legal side, the court will have to come out with a clear ruling. And that's where I think I'm of a firm belief that the government at some point in time will have to come out with a legislation clearing all this air. Otherwise, we have a problem of courts interpreting this, different courts interpreting in different fashion and manner, and then every matter landing up going up to Supreme Court. This is going to create a chaotic situation.
Thank you.
Thank you.
Hi, sorry, Kaustubh here. Just one small addition to what you said right now, if you don't mind.
Yeah, go ahead, Kaustubh.
Yeah, so about the migrant workers thing, that circular mentions 5 different measures, and all of them except for the specific one which directs employers to make payments of wages specifically mentions migrant workers, whereas the measure for payment of wages is saying workers. So, I mean, that might be something that comes into use while interpreting that specific measure.
Yeah. I'm sure. I think the court will interpret it.
Yeah.
If there are no more questions, or if there are any more questions, members can write to the Swiss India Chamber of Commerce, and we would be happy to pass them on to Suhas to answer them. Let me take this opportunity to thank Suhas for his very exhaustive presentation. You covered all the topics of the ranging from statutory and regulatory pronouncements to the contractual implications of force majeure and the interplay between frustration and force majeure, the legal responses to the pandemic health, including how finance and compliance of the new SOPs, which everyone has to now follow. Social distancing is the new norm, and of course you went to a very important point of altering business relations in the sense of how parents and subsidiary companies would be experiencing their difficulties, how joint ventures would be also be coming into the same bucket, the lender-borrower relationships, how they are playing out, and the landlord-tenant one. You also mentioned of the Supreme Court judgment in this regard. And of course, we were talking all this while about the employer-employee relationships. The new behavior and trends in the judiciary and some of the landmark judgments during the lockdown period were also highlighted by you. But before I close down, I would give a special thanks to you, Suhas, for having invited Dr. Ajit Mogekar, Mrs. Alka Patil, Ms. Swati Nahar, and Gary Hofstetter in your presentation. And it's something which is very touching. You have really not just made it a pure legal presentation, but you did know that this is in the times of COVID. So you acknowledged them, and thank you so much to each of you, Dr. Mogekar, Ms. Patil, Ms. Nahar, and Mr. Hofstetter, for having taken your time out and being part of this webinar. And last but not the least, Suhas, I liked in each and every slide, you have these paintings and art forms, which is something which is very incredible. Thank you, Suhas, and thank you everyone for having participated in today's webinar. Stay tuned for the next webinar from Swiss India Chamber of Commerce. Thank you, everyone.
See, before we log off, may I request each one to switch on their videos? We just want to take and try and see whether we can capture a comprehensive picture.
Okay.
If everybody switches on the videos, please.
Suhas, the webinar feature of Zoom does not allow participants to switch on their cameras.
At least the panelists, Gary,
Yeah.
Gary, Swati, Mr. Shivaprasad.
Yes.
Suhas, I'll be able to take picture if you can stop sharing the screen.
Okay.
Gary, we would request Gary, Swati, Shiv Prasad, everyone to switch on their cameras. Since they are away.
No, I guess they're away. I think.
Yeah.
Okay. We should have announced that up front. Okay. Thank you very much. Thank you, everybody. Thanks a lot, Mr. Shivaprasad.
Thank you.
Thank you
very much. Bye-bye.
Bye-bye. Thank you. Take care.
Thank you, everyone.
Stay safe, everybody. Thank you.